$30 to perform oral sex more than once.
Right. So.
But, Your Honor, I understand the state's position on it, but it's about charging it correctly. This wasn't a venture, Your Honor. This was there wasn't a third party involved. This was the victim and the defendant. This is solicitation. We could go, there are a number of charges, but human trafficking just isn't one of them based on the definition of the statute.
Your Honor, I'm not sure how to say it any other way. It is a definition within the statute. It is not a definition that is used within this particular section of the statute. So venture is not what is alleged here.
But it's
78706-3
G.
G.
It does not say anything about a venture in that section.
Your Honor, in 3, it says any person who knowingly or in reckless disregard of facts engages in the subject, and then it ends or benefits financially by receiving anything of value from the participation in a venture that is subjected to a that has subjected a person to human trafficking. And then further into its G provision, it brings up the child, and that's where it's relevant in this situation, Your Honor. So I do believe that it does include venture. And in the sentence right above that provision is the definition of venture. And above it are all the definitions of relevant terms that are going to be used throughout the statute. So I do think venture is relevant. I think it's relevant here, and it's probably relevant in other areas that aren't relevant to the defendant. But the charge that the police used is just incorrect statutorily.
All right, I respectfully disagree. So I'm going to find probable cause on 1, 2, and 3. On 1, I'm going to send him a no bond pending a pretrial detention hearing.
Your Honor, as the court has found probable cause, only with this case am I going to ask that you hold him no bond pursuant to Arthur. If the court does agree, then there would be no pretrial detention.
Right.
I would say that there is proof evident presumption great, Your Honor, based on the text messages, that there was more than enough evidence that it was transactional for sex, and that also that the child was less than 18 years old, Your Honor.
So light felony then, correct?
I'm sorry?
No light felony?
Yes, Your Honor.
Okay, so it's a light felony, so I don't have to set it for a pretrial detention hearing.
If I ask for it to be
Arthur.
found under Arthur, then no, Your Honor, you would not ask for it.
Okay. So I'm going to hold him at no bond, find probable cause. I'm going to appoint the public defender to represent him. No bond on count 1. Count 2, state, you have input on bond on count 2?
I'll leave it at the court's discretion, Your Honor.
All right. Set the bond at $10,000 on count 2 and $5,000 on count 3. Order no contact with the alleged victim in this case. No use of the internet or computers while this case is pending. If he gets out, state or defense, you are free to file a motion for a bond reduction if you want, you know, before the judge has assigned the case. But for right now, I'm going to find probable cause and order him held at no bond under Arthur, given the facts on the case. So I did appoint the public defender, so you can address it accordingly. All right?
Did you find proof of evidence?
Proof evident, presumption great,
Okay.
and order him held at no bond under Arthur.
Is there a date? Is there a hearing under?
Nope. I don't have to set a hearing on it. If they're moving for no bond under Arthur, I don't have to set a pretrial detention date hearing. So you can certainly file a motion for a bond reduction if you want.